Hello, and welcome once again to another episode in our series Million Dollar Breakdown. As always, today's discussion will be an information-packed overview of a major case with a verdict in the millions. And today we're speaking to Mogan attorney Grant Gillenwater, who, along with his colleague Derek Connell, recently won a really impressive verdict in excess of $1.5 million. Grant, welcome.
Hi, good morning, Carl. Thank you so much for having me on.
So let's begin with you letting us know just a little bit more about what transpired, about the actual incident that resulted in this case.
Sure. So the incident stems from a crash that occurred in February of 2020. My client was a passenger in a vehicle being driven by his son, and they were going to make a left-hand turn, and the defendant, who was visiting from out of town driving a Jeep, was not looking where she was going, was trying to find the entrance to a Home Depot or something like that. Just came up, slammed into the back of my client's vehicle with such force that it pushed his vehicle into the back of the vehicle in front. So not only was there one impact from the rear, but he experienced another impact again from the front. It was a significant crash.
In terms of the pre-trial offer, correct me if I'm wrong, but the last offer was around $200,000. Is that correct?
Yeah, yep. I believe it was either 200 or 250,000. I want to say it was 250.
So tell us a little bit more about the client. I mean, what was their life like before all of this happened to them?
So Scott's a great guy, a true family man, someone that his life revolved around his family, his kids. He has, his wife, a wonderful man who would do anything for him, was very active with them, would go out with his younger daughter and play in the yard, would play catch and ball with the kids. He's got a couple older kids as well. They would ride motorcycles together. I mean, just a very active man who did a lot with his family. And unfortunately, as a result of this crash, he sustained significant and permanent injuries to his neck and low back, which, precluded him and continues to preclude him from doing a lot of those activities that he used to. Now for the very first time in his life, he's faced with this decision of, hey, go outside and play catch with the boys and suffer for it tomorrow and live in pain, or sit here on the couch and don't do that. And that's a decision that no one should have to face. And there's value when something like that is thrust into one's life through no fault of their own.
When you look back on the case, what do you think were the factors that this case hinged on?
So really, in this case, and I think in most cases, it comes down to the credibility and believability of the client. And fortunately, I've been very lucky in my practice with Morgan & Morgan to have clients that I have always believed in and I have always listened to. And people, in closing arguments, I hear a lot from the defense. They get up and they say, look, our numbers are so far apart, and you might be wondering why. And they say, well, we don't know why. Or they suggest that is because the plaintiff is being greedy. No, what it is when I get up and rebuttal, I say the reason our numbers are so far apart is one simple thing. It's because I believe the person I'm sitting next to and the insurance company doesn't. And that's the difference. It's the faith, the belief, the trust that the person I'm sitting next to representing, advocating for, is truly in pain and truly has had life-altering, injuries thrust upon them. And that's the difference. So for me, every case always hinges on my client and the credibility and trustworthiness of my client.
Having said that, then, what was the biggest obstacle that you faced in the case?
No doubt on this case, the biggest obstacle were the defense attorneys. We had to try this case twice, 2 weeks in a row. The first trial ended in a mistrial with sanctions against the defense attorney for underhanded tactics and tricks, essentially showing photographs which were kept out of evidence and flashing them to a jury after the judge had specifically instructed that not happen. So the first case ended in a mistrial, and he called us back on Monday. We tried the case again. Again, the defense team in this case, they were by far the biggest obstacle because they were trying every trick in the book to make our client look like a liar, to make him look like he was greedy, to make him look like a lowlife, and it's disgusting. It's disgusting what these folks will do and at what lengths they'll go to try to keep money in the pockets of the insurance company. And that's why, and that's truly what drives me every single day, because we're doing good work for good people, and the other side just, I couldn't do it. I don't know how they sleep at night.
Jury selection must have been pretty complex then, given the history of this case. How did that go?
So jury selection for me is always complex because I like to take my time. I just got out of a trial last week in Naples. Jury selection took 2 days. I tried a case in West Palm last year. Took a 3 or a 4 day jury selection. So I take my time in jury selection. I do not let a judge rush me if I can help it. Jury selection, I think, is the most important part of a trial. You've got to do your best to understand who is going to be sitting on this panel and who you're ultimately going to be talking to. So for me, I like to slow it down. I like to take my time. Obviously, we're restricted in that we cannot pre-try our case. We can't talk about the facts. But I use a lot of analogies, a lot of hypothetical questions to try to explore some of the issues that I know are going to be coming up and coming out in the trial. So jury selection in this case was my typical jury selection. I think I took 4 or 5 hours, and really try to delve in as much as possible. I always like to start out by just getting baseline biases, talking about well-held opinions and beliefs, and really try to narrow down and see who we're talking to on this panel. The tough part in Brevard County is we're a pretty conservative jurisdiction. We've got a lot of engineers. We've got the Air Force Base here, so we've got military, retired military. It's a pretty conservative jurisdiction, so I've got to really wade through some murky water to find out what is at the core of these people's beliefs, and if they're going to be on board with awarding a multi-million-dollar verdict if the facts and the evidence justify it.
You mentioned that your biggest obstacle was opposing counsel. So how did you prepare for the arguments that they were going to bring?
Yeah, so the nice thing about them is they couldn't keep their mouth shut. They basically just showed all their cards on day one. So it wasn't, a guess as to, well, which angle are they taking or which path are they going to go. They laid their cards out on the table weeks before we even stepped into the courtroom. So fortunately, I knew where they were headed, and I was able to predict where they were going, and kind of short circuit some of their arguments. The thing for me, and this is one thing I think a lot of attorneys don't do. A lot of attorneys like to run from bad facts. They hope that they can hide them or shove them down in a case, or downplay them. I do the complete opposite. I bring my bad facts to light first. I want to control my bad facts. Let me put my spin on the bad facts. Let me frame them, as Keith Mitnick would say, in the way I want them framed. And then the defense comes after me, and they look like fools because I've already framed the bad facts in the way I want them framed, and now it looks like they're trying to do something that may be, a little shady to the jury. So I never run from bad facts. I pull them out, I bring them out, I step right up in front with them and say, look, you're going to see X, Y, and Z, but let me tell you why X, Y, and Z is not important. And then when the defense gets up and says, well, X, Y, and Z is important, the jury's already heard, wait a second, it's not important, and here's why. So I'm giving them this argument before the defense even gets up to do anything. So for me, that's how I've always dealt with the defense strategy is I get out in front of it and I spin it my way.
Excellent. You mentioned closing arguments a little bit earlier on, but I wonder if you could dig down a little bit more about how you completed that process.
Sure. So, in this case, again, they were trying to say that, first of all, my client's son did something wrong, that he short-stopped, which caused the crash. They then said that my client overtreated. They then said my client treated with doctors who overcharged, or that he had medical procedures that weren't related to the crash, but rather some underlying condition which he had before. We all have degeneration. I mean, you and I have it. Everyone listening to this has some amount of degeneration. It's just the normal aging process. My beard wasn't as gray as this last year. That's as an example of degeneration. It happens. But the defense loves to use that degeneration. And so, in closing, when they just throw everything out at the wall and to see what sticks, it's really important for us to be very, very pinpointed as to the direction we're going. We're snipers. They just get out with a machine gun and start shooting all over the place. Derek and I, in this case, in the first closing and the rebuttal closing, we're like snipers. We have to pinpoint the attacks, make the legal arguments, and then move to the next one. So it's very logical and well thought out. The rebuttal you can't plan for. The rebuttal, you just, have to listen to their closing and get up, and that's probably one of the most fun parts of a trial. But the first closing, the main closing, that's where you can really dig in the night before, look at all the facts that have come out, look at all the evidence. I'm a big proponent of putting medical records up digitally, as I'm talking about different things. I want the jury to see the evidence, and I talk with them about the bait stamp numbers so they can go back and hold it and look at it and say, okay, this is what he was talking about right here. I don't just like to say it. I want them to see it, because a lot of folks, most folks, are visual learners. So for me, closing, I always use those medical records, but it's a very pinpointed attack and approach where the defense just gets up and kind of sprays the machine gun bullets everywhere and see if they can hit something. Sometimes they do, a lot of times they don't.
Awesome. So in retrospect, what did you learn from this case? What were the takeaways for you?
Sure. So on this one, I think the big takeaway on this is you just, as much as you want to, as much as I want to trust folks that enter into the arena with me, that they're going to uphold the ethical standards that the courts have laid out, and they're going to play by the same rules that we should all be playing by, that doesn't always happen. And we want to think the best in folks. We want to hope the best, but we have to be ready for things to go awry and for people not to be playing by the same rules that we're playing by. And when that happens, we have got to have the courage to let the court know. We have got to keep pressing and pushing the judge. And that's ultimately what happened. These things kept happening over and over and over that the defense were doing. And each time I felt like a broken record. Judge, here they go again with this. Here they go again with this. And finally, after 4 days into trial, the judge said, you know what? I've had enough. This is a mistrial. You're going to start again next week, and we're going to sanction the defense. And you just have to, you feel awkward doing it, but you just have to go and push and push and push and push. Because if you don't, you're not doing the best job for your client. So I think the takeaway from this is that even though things may feel uncomfortable and may feel unnatural sometimes, if it's in the best interest of your client, you do it. You have to do it, and you have to keep going. And even if the judge looks at you and says, well, whatever, you have to make your record. And for me, and for this case, and for this client, certainly that worked out. I don't know what the result of that first trial would have been. There were a lot of things that occurred in that trial that shouldn't have occurred. Ultimately, that's why it ended in mistrial, and we retried it and got a fantastic result for the client.
Brilliant. Grant, thank you very much for joining us today, and congrats on the win and your persistence in this case.
Thank you so much, Carl. Absolute pleasure.